5 seconds to go. Start. Therein, an actor in a news magazine on the subject of premarital sex, wherein she had urged women and girls to take necessary precautions to avoid the transmission of venereal diseases. In doing so, this court observed that criminal law could not be set into motion in a manner as would interfere with the domain of personal autonomy. The court upheld the appellant's freedom of speech and expression and quashed the FIRs, expressing the need for tolerance even qua unpopular views. As per the dictionary meaning, the expression advertise means to draw attention to or describe goods for sale, services offered, etc., through any medium such as newspaper, television, or other electronic media, etc., in order to encourage people to buy or use them. In other words, it is to draw attention to any product or service. Advertisement is a public notice, announcement, picture in a newspaper or on a wall or hoarding in the street, etc., which advertises something. In short, it is to advert attention to something and, in the commercial sense, to draw attention to goods for sale or services offered. In that sense, an advertisement is commercial speech. A glimpse of the following cases would be useful. In Hamdard Dawakhana Waqf Lal Kuan versus Union of India AIR 1960 SC 554, this court held that an advertisement is a form of speech, but its true character is reflected by the object for the promotion of which it is employed. However, this court qualified its observations with the caveat that when advertisement takes the form of commercial advertisement, which has an element of trade or commerce, it no longer falls within the concept of freedom of speech, for the object is not propagation of ideas, social, political, or economic, or furtherance of literature or human thought, but the commendation of the efficacy, value, and importance of the product it seeks to advertise. In the said case, this court did not recognize commercial speech on par with other forms of speech by holding that it did not have the same value as political or creative expression. That broadly, the right to publish and distribute commercial advertisements advertising an individual's personal business is a part of freedom of speech guaranteed by the Constitution, but not every advertisement is a matter which comes within the scope of freedom of speech, nor can it be said that it is an expression of ideas. In every case, one has to see what is the nature of advertisement and what is the business commercial activity falling under Article 19(1)(g) it seeks to further. In Rudul Shah versus State of Bihar 1983 4 SCC 141, Y.V. Chandrachud, Chief Justice, gave further momentum to fundamental rights to combat state lawlessness by granting cash compensation to a victim of unlawful incarceration for 14 years. It is to be noticed that His Lordship in the said case took note of the dilemma in allowing a litigant to seek damages in a writ petition PIL action against the state. His Lordship noted that this could have the effect of ordinary civil action being circumvented on a routine basis by invoking writ jurisdiction of the High Courts and the Supreme Court as an alternative to ordinary civil action. However, it was recognized that granting such remedies would enhance the legitimacy of the vehicle of PIL. Therefore, this court in Rudul Shah ultimately chose to grant monetary damages in order to mulct the violators as well as to offer a palliative for victims. Subsequent to the decision in Rudul Shah, compensatory relief has been granted as a means to civilize public power in several cases involving abrogation of fundamental rights. This court observed that the award of compensation in a proceeding under Article 32 or Article 226 of the Constitution is a remedy available in public law based on strict liability for contravention of fundamental rights. In respect of such actions, the doctrine of sovereign immunity does not apply, though It may be available as a defense in a private law in an action based on tort. Drawing a distinction between proceedings under the private and public law, it was observed that a public law proceeding may serve a different purpose than a private law proceeding. Public law proceedings are based on the concept of strict liability for contravention of guarantee basic and indivisible rights of the citizens by the state. The purpose of public law is not only to civilize governmental power and but also to assure the citizens that they live under a legal system which gains to protect their interest and preserve their rights. Therefore, when the court molds the relief by granting compensation in proceedings under Article 32 and Article 226 of the Constitution seeking enforcement or protection of fundamental rights, it does so under public law by way of employing elements of the law of torts and fixing the liability on the state which has been negligent and has failed in its public duty to protect the fundamental rights of the citizens. The payment of compensation under such cases is not to be understood as it is generally understood in a civil action for damages under private law, but in the broader sense of providing relief by ordering monetary amounts to be paid for the wrong done due to breach of public duty, which would have the effect of violation of fundamental rights of citizens. Such grant of damages in exercise of a writ jurisdiction by the constitutional courts is independent of the rights available to the aggrieved party to claim compensation under private law in an action based on tort. Stop.